Welcome to Alumni Reunion Weekend 2022. We're so happy to be in person. My name is Veronica Alexander. I'm the Assistant Dean of Development and Alumni Relations here at Berkeley Law. I joined the law school as part of the team on June 6th, so this is an exciting reunion weekend for me. I spent a number of years at UCLA Law School, followed by UC Irvine Law School, where I worked with Dean Chemerinsky, and had a short stint at Berkeley Social Welfare before joining the family here at Berkeley Law. So it gives me great pleasure to present who I am and then to invite you to be part of this wonderful CLE. Before we begin with the program, I have a few housekeeping items. The session will be followed by lunch, which is available for pickup in the Alumni Lounge. The session will count for 1.25 hours of CLE. Be sure to sign up at the Reg desk and pick up your certificate before leaving. If for some reason you don't remember to do that, no problem, no shaming. Information is available on the website. If you haven't already done so, make sure you sign in, as I mentioned. So it gives me great pleasure to introduce Professor Liz Semel, who's been pursuing fairness and justice for an incredibly long time, starting in the mid-1970s as a deputy public defender, followed by entering private practice in the early 1980s, where she defended criminal cases in state and federal courts. As the former director of the American Bar Association's Death Penalty Representation Project in Washington, D.C., she gained tremendous skills and expertise, making her the most exceptional lawyer to serve as the inaugural director of the Death Penalty Clinic here at Berkeley Law, which was founded in 2001. In addition to her incredible legal career, she is an extraordinary scholar with dozens of publications. I'm happy also to introduce Professor Ty Alper. After obtaining a Master of Law degree, Professor Alper joined the Southern Center for Human Rights in Atlanta, where he represented Alabama and Georgia death row inmates in state and federal post-conviction proceedings. As the previous Associate Dean for Experiential Learning at Berkeley Law, Ty's current role as co-directing the Death Penalty Clinic is a reflection of the school's goal to provide our students with the scholars at the highest levels of the profession, and Ty is exceptional by every measure, not least of all his publications, and especially a nod by Justice John Paul Stevens, who cited Ty's research into state animal lethal injection protocols. Please help me to welcome Ty and Liz.
Well, good morning, everyone. It's a pleasure for all of us to be with you today to talk about the Death Penalty Clinic, where we started, where we've gone, and where we hope we're going. It was extremely important to us, to Ty and me, that you have an opportunity to meet three of our alums. I should note that I want to just say that as I'm looking out, two more of our alums at least are in the audience, Ann Shaver and Jackie Simonovich, and wait a minute. Oh my God, say it out loud. Mir, what are you doing here? I was so shocked, I can't believe it. All the way from DC. That is wild. Okay, are here. So that's even more exciting. I was looking at Mary and I'm thinking I'm hallucinating. All right, so I'm going to just quickly introduce Nisha, who's immediately to my right. She's class of 05, Death Penalty Clinic 05. There she is. So, a little nostalgia. There's Nisha with her class. So she graduated from the law school in 05. She is the legal director of the Habeas Corpus Resource Center, which is essentially California's state's habeas corpus resource giant for capital cases. She's represented indigent people sentenced to death in state and federal courts in California since 2006. She also co-taught the criminal law ethics seminar at the law school this spring. Before working at HCRC, Nisha clerked for Judge Joel August in Maui, Hawaii. Van Swearingen, who's immediately to my left and now on the screen with his classmates in the clinic in 08, graduated that same year. He is a partner at Rosenbein, Galvan, and Grunfeld in San Francisco, where he practices in areas of complex civil litigation, employment law, civil rights, and First Amendment. He's currently working on to improve conditions of confinement for people incarcerated in the jails of Monterey and San Diego counties. He received a California Lawyer of the Year award in 2016 for expanding access to early release family reunification program administered by the California Department of Corrections and Rehabilitation, and another Clay Award in 2022 for stopping the Trump administration from implementing a wholesale ban of WeChat, a widely used Chinese language social media platform. Immediately to Van's left is Ruky Tijani, who graduated in 2014, and you can see her up there in action in a meeting of the clinic and some of our co-counsel. I know. How about that? She looks so serious. She is a Nigerian-American first-generation professional from the projects of Brooklyn, New York, who is licensed in California and New York. She is a trademark attorney and founder of the culture and creator, of the firm For the Culture, where she's also the CEO. She founded the firm after years of serving as an intellectual property attorney at a prominent Silicon Valley law firm. And the firm For the Culture was born out of Ruky's passion for the law, social impact, social entrepreneurship, and strategically scaling to create substantial change. So now we will get rolling with the actual conversation about the clinic. So this is actually our 21st year in the death penalty clinic. I know it's really kind of a remarkable feat when you think about it. Ty and I are, we don't look a day older than the day we came to Berkeley. But the truth is that I got here in July of 2001. The clinic started in August of 2001 with 8 students and no clients, and with 1.5 faculty. Chuck Weisselberg, who many of you will remember, who taught you criminal procedure perhaps, was loaned to the clinic as a half-time faculty member to work with me. We have now represented more than 45 clients at different stages of the proceedings in about a dozen states across the United States. And about 330 students have spent a year in the death penalty clinic. And there's another one, James Chavez, another death penalty clinic alum. We started, as I said, with 1.5 faculty, no administrative support. We now have 2 full-time clinical faculty, a full-time clinical supervising attorney, and a paralegal. And I would be remiss if I did not say what an enormous difference it has made to the entire clinical program to have Erwin Chemerinsky as the dean, someone who believes in what we do, in experiential learning, in all of the clinics. It's just made an enormous, enormous difference. I want to mention that our alums are spread across the country and the world. They are entrepreneurs, they are law firm partners, they are public interest professionals. About 60% of the death penalty's alumni are engaged in public interest, public service careers, which is quite a percentage when you look at the law school overall. So I'm going to speak just for the next few minutes about a theme that has run through the death penalty clinic's cases since its inception, and that is the relationship between race and capital punishment, because capital punishment in this country is rooted in the legacy of slavery, racial terror, and subjugation, and it really has been a connection to the work we've done since we've started. So I'm going to speak thematically and a little bit chronologically about how the clinic's mission has intersected with the essential feature of capital punishment. Ty is going to talk about why we do so much of the work we do in the South and use the state of Alabama as kind of a jumping off point for illustrating that other aspect of the mission of the clinic. So one of the ways in which we have focused on the issue of race has been at the inception of a capital case. And I want to emphasize when I say this that I'm going to talk about some systemic and structural issues, but every one of them has its genesis in an individual client who we represent or represented. So for example, in San Diego County, we represent a client by the name of LaTuan Weaver, who was sentenced to death there in 1993. And as part of the numerous claims in LaTuan Weaver's case, we investigated for a number of years the question of whether or not the San Diego District Attorney was actually selecting people for capital prosecution in a way that was racially discriminatory. So with several years of students working to plow that field, litigating to obtain the data that we needed to do an empirical study, we finally, a number of years ago, were able to conclude that study. And the result of that study, which is part of the litigation on behalf of Mr. Weaver, is now in the case. And what we were able to demonstrate through all of that incredible student effort and two terrific social scientists is that Black defendants convicted of the murder of white victims were substantially more likely than defendants of any other of the 5 defendant victim racial or ethnic combinations to be charged with a capital eligible crime, to face the death penalty, and to actually be sentenced to death. The significance of what we did in San Diego County, we hope will be important to Mr. Weaver. But a point that needs to be made is that it is connected to studies that have been done in other California counties and across the United States. That is to say, what we found in San Diego is the norm and not the exception. The other thing the clinic has been involved in is looking at what happens when we actually pick juries in death penalty cases. So back in 2014, when actually Jackie was in the clinic, we started kind of the year after Jackie was in the clinic. When Jackie was in the clinic, we were working on a case in Fresno County. That's right, yes? Is that right? Was it the Fresno case? Yes, it was. Before that, we did Solano County. But the point of this slide is that we have litigated in 4 California counties in actually 6 cases, looking at what happens when jurors are death qualified. What I mean by that is in a capital case, and only in a capital case, are jurors asked about their views when it comes to the death penalty. The consequence of that kind of questioning is that you not only strip the jury of people who have reservations about the death penalty because the law permits them to be excused. What you do, and what we have argued in these cases, and now in another case in another state, is that you disproportionately remove Black jurors and women from those juries at the very beginning of the process. Because historically, experientially, and statistically, Black folks are more likely to oppose capital punishment than white jurors. So what we have done is looked at this process of death qualification through the lens of racial discrimination. And in each of these counties, we did surveys to demonstrate as a matter of social science that these projections, in fact, are true. So that's what we've done in those counties on behalf, again, of individual clients who are facing the death penalty, trying to reshape how jury selection would happen on their behalf. The next piece has to do with what happens when you're actually picking the final 12 people who sit on the jury. And this started with literally one of the first cases that we took in the death penalty clinic, Thomas Miller L. And in his case, the issue was the exercise of peremptory challenges. And for all of you, know that peremptory challenges are challenges that can be made against individual jurors for no reason whatsoever. Each party, prosecution, defendant, plaintiff, defense, gets a certain number of those challenges, and they can be exercised for no reason unless the opposition can show that race or gender or some other impermissible group identification was the basis. So in Thomas Miller L's case out of Texas, we argued that indeed race discrimination was at the heart of the exclusion of every African American from Mr. Miller L's jury, save one. And we did that in a number of cases in the United States Supreme Court. And finally, after litigating this issue many, many times on behalf of many clients, including in Alabama, including in California, et cetera, a couple of years ago, we embarked on a study to look in a systematic way at how peremptory challenges were being conducted in the state of California by prosecutors. And we issued this report, Whitewashing the Jury Box, which 5 students participated in. It's both a quantitative and a qualitative study of what happens when prosecutors exercise these challenges in California, demonstrating, again, that they're exercised in a racially discriminatory manner. The purpose of that report was to advocate in favor of a bill that the clinic helped draft, AB 3070, that basically took the way that peremptory challenges are exercised and evaluated by judges, turned it on its head and said, we need a different procedure to ensure that jurors of color, particularly Black jurors, are not disproportionately excluded. And in 2020, Governor Newsom signed that bill into law. It's the first piece of legislation the clinic had ever helped to draft. So we start, kind of we're one for one. But it was and now that is the law that applies in all criminal trials in California. I'll just mention the brief that we did, again, always tied to the representation of a client. In Dante McDaniel's case, this is a brief that the clinic did with Dean Chemerinsky on behalf of a defendant on California's death row. And in that brief, which had to do with the way jurors make the life and death decision in these cases, we brought together a lot of the data I've been talking about this morning to argue that all of these considerations about the history of the death penalty, its present day application, how it discriminates in charging, how it discriminates in jury selection, mattered to the decision in Mr. McDaniel's case. And I'll just mention last that what we are trying to do is to look with as wide a lens at these issues as possible. So last year, several of our students who are depicted there, Max Endicott, Aisha Spencer, and Maddie Pilgrim, who just, happened to be on the cover of the clinical program brochure for this year, worked on a report looking at, of all states, the state of Kansas, and looking at how juries are selected in Kansas and doing a study that found, yes, again, in the state of Kansas, prosecutors discriminate against Black jurors in the exercise of peremptory challenge. That was on behalf of a particular Cornell McNeil, an individual who was facing the death penalty in Kansas. Ultimately, death was taken off the table in his case. So there we are. That's just to kind of give you an overview of the many ways in which we have tried to be attentive to, sensitive to, conscientious about challenging the most, I would say, decisive feature of how capital punishment affects our clients.
All right. No offense.
None, absolutely. It's going to go right back down.
Yeah, that's true. Hi, everybody. So Liz talked about race, and I'm going to talk about the state of Alabama and our work in Alabama. And then we're going to turn it over to our 3 amazing alums to talk about their experience in the clinic and how it has shaped their careers. Why Alabama? So and Liz alluded to this, but we represent or have represented people in clients in Arizona, California, Georgia, Texas, Virginia, Kansas, Missouri. But we have an Alabama focus, and we wanted to focus on it a little bit today because it epitomizes what we do and how we select the cases and the projects to work on. Our mission is to provide high quality representation to clients who desperately need it, and to teach students how to provide that representation. And the clients who need us the most are the clients who can't otherwise access quality representation. And what that means is that we often end up taking cases nobody else will take, either because there's no money in it from the courts, or because there was something about the crime that was particularly bad, whatever that means, or the procedural posture of the case is particularly tricky. We're not an innocence clinic. Once we take a case, we take it no matter what the issues are that it presents, and we see it through wherever it goes, whether we're in the state trial court or the United States Supreme Court or elsewhere. And Alabama happens to be the only state in the country that does not provide counsel to people on death row in the critical state post-conviction appeals process. So if you're on death row in Alabama and you need a lawyer, which everybody who's on death row in Alabama does, you either have to find a lawyer at a nonprofit like the Equal Justice Initiative or the Southern Center for Human Rights, or get a law firm to take your case pro bono, or find a clinic like ours to represent you. And for 2 decades, we've represented 3 clients on death row in Alabama. We've consulted on a number of other cases, but we've provided representation to 3 clients whose cases have provided our students with opportunities to experience and really make a meaningful contribution to all aspects of what it means to represent someone who the state is trying to execute. We're lucky to have three of these alums with us here, and 3 or 4 more in the crowd. And they can talk about their experiences. For me, one of the best parts of my job, our job, is traveling to do field investigation with our students. Here I am on the left with some students just last year on a plane to Alabama, and on the right is Liz and 2 of our students in I think it's the Montgomery airport, waiting for something. The trip on the left was to interview witnesses to Forrest Johnson's case, which I'll mention in a moment. I think we knocked on 75 doors that trip. We spoke with 60 different witnesses over 5 days in Birmingham. And on the right is the trip to Montgomery for oral argument that we conducted in the appellate court in the Alabama Court of Criminal Appeals in Willie Burgess's case, one of the other Alabama cases that I'll mention in a minute. And this slide shows us and students outside 2 different Alabama courthouses in the same case, Willie Burgess's case. The photo on the right was taken in 2005, right? Which you can kind of tell by the quality of it, with like a real camera. And then on the left was just this past year in the beautiful Alabama Supreme Court building where the Alabama Supreme Court and the Court of Criminal Appeals are, and on the right is the state county courthouse. So same case, arguments in 2 different courts separated by if I could do 15, 17 years. It kind of shows both the span, the incredible span of these cases, and the fact that we're in it for the long haul with our clients. This is Willie Burgess, who's been on death row for almost 30 years. For a crime he committed when he was 18 years and a few months old. If the crime had been committed a few months earlier and he wasn't yet 18, he wouldn't be on death row today, which points out, in some ways, the real arbitrariness of the death penalty. This is Willie in elementary school, obviously, a photo that I chose deliberately because so much of what we do in the clinic is telling our clients stories. How did these children become people who were sentenced to death? What childhood trauma did they experience? What abuse did they suffer? What limitations did they live with? What protective factors that most of us take for granted were completely absent from their lives? We want judges and juries to remember that our clients are human beings who were all once innocent children, shaped and molded by factors that were almost always out of their control. And that takes a lot more than just showing a cute photograph. It takes hundreds of hours of investigation and talking to witnesses, consulting with experts, pouring through records. And that's what our students do. This is a picture of some of them out in the field, working on their laptop in the car, sitting around the table at the Airbnb that they were in for a week. people think of, and our students sometimes come to the clinic thinking of lawyering as either giving a closing argument or writing a brief, or we do a lot of briefing, but a lot of what we do is fact development, out in the field, marshaling the facts that we need to represent our clients. Sometimes, although we're not an innocence clinic, we find ourselves with a client who is innocent, who did not do the thing that he's on death row for, who is not there at the crime scene. And that's the case with one of our cases, DeForest Johnson's case in Alabama. This is a case that has presented opportunities for students to engage in truly creative advocacy. This is an op-ed in the Washington Post that the former Attorney General of Alabama wrote. One of our students, who was a former journalist, worked with him extensively on this piece. This is another project in the same case to raise awareness about the case, where we took advantage of the World Games in Birmingham this past summer and to put up this banner on a building of one of our community partners, the Greater Birmingham Ministries, happened to be across the street from Protective Stadium, which was the main venue for the World Games. And they put up this banner with a QR code linking to a website, to forestjohnson.com, which you can all visit later. And a student is now leading the effort to work with faith leaders across the state to take this banner basically on a tour of churches in rural communities around Alabama to raise awareness of this case and try to build support for it. It's not necessarily what the student thought she was going to be doing when she joined the clinic, but she's really excited about it, and it's a key component of our overall advocacy strategy. And then this is Mark Jenkins, our third client on death row in Alabama when he was in middle school. He's also been on death row for more than 30 years. And his traditional appeals have actually been denied. So we are sadly in new territory for the clinic. We're working on a clemency application for the governor of Alabama. This picture on the left is not a very good picture, but what it is two of our students interviewing the brother of our client for a clemency video. The student is sitting on the floor, has the audio equipment that she's listening to, and the other student is interviewing him on camera. And I was just on the other side of the hotel room documenting it for this panel. So we've had to learn sound, we've had to learn cinematography, we've had to learn video editing. We have a pro bono award-winning documentary film editor who's working with us on the case. And we're also now working with a big prominent national law firm on litigation related to challenging the way that Alabama intends to try to execute our client, which is nitrogen hypoxia. It's a form of execution that's never been used in any jurisdiction in the world, and Alabama is trying to do it. So we're students and a law firm that we have on board are working on potential challenges to that method of execution. And these cases bring new challenges every day, but they also bring opportunities for our students to learn what it means to zealously and creatively represent clients in desperate need, how rewarding it can be, even how fun it can be, but ultimately how impactful it can be on the lives of our clients and their families. And we're really excited to have 3 people here who can tell you firsthand what their experiences were doing that. So I will turn it over to Nisha.
I'm going to move this back down. All right. So I was, unfortunately for me, I'm the oldest alum here. And I was in the clinic from 2004 to 2005. So this was, kind of in the early years of the clinic. And Ty actually first joined the clinic my year. I think one of the most meaningful things about my clinic experience was meeting one of the clinic's clients, Willie Burgess, who both Liz and Ty talked about. I came into law school thinking I would be a public defender and do trial level criminal defense work. I ended up going on almost kind of like a straight line from the clinic to doing death penalty post-conviction work in California. And a large part of that for me, I think a large influence was meeting our client. Liz had a longstanding relationship with him by that time. And, as I think both of them talked about, most people sentenced to death end up there because they didn't have resources. They grew up in, great poverty, in situations where they just didn't have the means. And so in our case, what I saw was, Liz just developed this great trust with a client who had every reason to sort of mistrust lawyers, right? Lawyers were the ones who got him sort of on death row in the first place. And it was Liz's ability to really hear the client and his concerns that made the greatest impression on me. And what I saw was a skill that I didn't have by any means, but wanted to work to develop. The other sort of major thing I remember doing in the clinic was investigation in Alabama. And that investigation was really a mix of meeting the client's family, actually members of the client's community in the town where he grew up, and reviewing a bunch of old records. And actually that involved reviewing old records on microfiche, which I remember made me motion sick. So I had to take breaks because I felt like literally ill. And going to funeral homes, because what we were trying to do was sort of similar to what Liz talked about with the Weaver case, is we were trying to investigate and find information about the race of victims so that we could do this sort of study in the county about the racial impact of the death penalty in that county in Alabama. And funeral homes and cemeteries in Alabama are segregated. And so you could figure out the race of the victims by actually going to the funeral homes and looking at the ledgers, which was a very strange experience. People in the funeral homes were actually very lovely. And it was a really kind of boots on the ground investigation to gather this information. And sure enough, what we found, and we worked with experts, is we found that, again, the race of the victim and the race of the defendant, as I recall, really had an influence on death charging, and death sentencing ultimately. That was really cool for me, especially working with the experts, because I actually had an undergraduate degree in math, which I know is it's a little strange for a lawyer, but that was my path. And so it was really cool to be able to kind of see this intersection of my interests. And I think it's one thing Liz and Ty are really great at, is kind of identifying their students' strengths. And I was someone who, frankly, was straight out of law school, so didn't have a ton of, straight out of college, I went to law school, so I didn't have a ton of experience, but I had this math background that helped me understand, to some degree, what the experts were talking about. One of the challenges in that situation that we faced was this U.S. Supreme Court decision, McCleskey versus Kemp. It's a 1987 decision in which the U.S. Supreme Court held essentially that statistics alone aren't enough to prove discrimination, that you have to show intentional discrimination, that the prosecutor actually selected, in this case it would have been Mr. Burgess, because he was Black, and that was the influence, and you can't show that just through statistics, right? And so the court, essentially said, yeah, this is true. We see these statistics are true, but that's not enough. And the dissent described that as a fear of too much justice. We tried to work through and talk through, well, how can we bring this claim in light of McCleskey? And I remember just thinking, well, why don't we just raise it? Whatever. Who cares what that case says? And again, I learned from these two actual lawyers that that's not the smartest path. And so I think we raised it under the lens of ineffective assistance of counsel. But I remember sort of just listening to their thinking through even, what would the other side say in a brief? Well, clearly they would cite that case, and just sort of learning these things that I had, frankly, no real understanding of before that. And I think the last thing that I remember sort of really hitting home for me was I actually happened to be in an airport in Alabama with Ty when Roper versus Simmons came down. And Roper versus Simmons is the US Supreme Court case that held that execution of a juvenile is unconstitutional. And they defined that strictly at the age of 18. So if you're one day past your 18th birthday, it doesn't apply to you. If you're one day before, it does. And, it was really great. And I remember us being really excited. And then it sort of hitting me that it didn't apply to our client, right? And that he was so close to that cutoff, and how sort of arbitrary the death penalty is. And I guess it was probably the confluence of all of those things that brought me into death penalty work. And like I said, I sort of the three of us here, I took the straightest line to do. I just went into post-conviction death penalty work. And I think, one of the influences that the clinic has had on my career is really this idea of building relationships with your clients. I've had clients for 17 years whose cases I've worked on, and observing the relationships that Liz and Ty built with them, with their clients, really continues to have an influence on me until this day. And my experience going to visit the client wasn't really about sort of practicing visiting a client. It was about watching what Liz did and learning from that. I think the other aspect of my work that it's been really important in influencing is racial justice work. As Liz said, racism pervades every aspect of the death penalty. And the data that we pulled together bore that out. And what we saw was that McCleskey was a challenge. And so one of the most exciting things I've been able to work on, it was actually the same year that the clinic was working on AB 3070, was providing technical assistance on the Racial Justice Act, which is California's bill that essentially sort of overturns McCleskey. And it says you do not need to prove intentional discrimination in order to show that the application of criminal justice, or the application of the death penalty, for example, in sentencing is unconstitutional, or actually violates the law, violates California law, I should say. And so it essentially rejects McCleskey's premise that racism is inevitable in our justice system. And that was a really exciting piece of my work. And then the last thing I will say that I think it has had an influence on is the idea that to do this kind of work, what you really need in spades is resilience. And I've seen that with Liz and Ty time and time again. I had a case that I had sort of the amazing opportunity to work on in my office, in which a judge declared California's entire death penalty system unconstitutional. And it was on the grounds that it's incredibly arbitrary. In California, over 1,000 people have been sentenced to death. 13 people have been executed. So even once you're sentenced to death, there's about a 1.3% chance you will actually get executed. And, languishing on death row is nothing, it can only really be described as torture. In that case, we had this great victory and lost on appeal for procedural reasons that are way too complicated to explain. But it was really exciting for a moment, and losing that kind of case on appeal is really difficult, even if maybe somewhat expected. And I think what gets you through those kind of experiences, or what got me through, is really the relationships that I built in the clinic, both with Liz and Ty and with other alums. And I was never sort of like a networking person in law school. I didn't really know how to do that. And the clinic is really my network. People who I was in the clinic with, I'm still in touch with. Some of them are my colleagues. And then Liz and Ty have just been touchstones for me throughout my career. And the people I call when I need help. And now we kind of get to be in regular meetings together, which is really cool. And I'm just really thankful for the experience overall. So I will turn it over to Van with that.
All right, good to see everyone. So I participated in the clinic from 2007 to 2008. Still going? Do this. Thanks, Ty. And was so excited to be part of the clinic. You know, I was an older law student when I came to Berkeley Law, and I was a little bit frustrated by the doctrinal classes in which the professors, the brilliant professors, tended to trace the evolution of the law from British common law to the present. And I just wanted to get to where we are today now and what the status of the law is. And often felt that the professors were kind of hiding the ball. And when I got to the clinic, I loved it because it was practical, and it actually allowed us to apply the law to the facts at hand and really kind of dig in and use our research and writing skills, the skills that I love to develop and wanted to develop further, to gain that, you know, quasi-professional experience while still being a law student. I was blown away by the class itself. It was a you know, set of, you know, not quite 20 people, but all of us were like-minded. All of us were dedicated to the cause, and immediately I felt that I had found my community within the law school. And before, I just had disparate friends, and this really was a really solid community, and everyone felt passionate about the work that we were doing, and everyone was interested in each other's work. I loved the clinic. I loved the clinical education. I loved that it was focused on a topic that had real life consequences that mattered a lot. I also, you know, Ty was my mentor, and his mentoring style was to ask me a lot of questions instead of providing me a lot of answers. But it was a really fruitful, engaging exercise. And most of my work that I worked on was with Mojgan Azaman, who is probably the person I'm most in contact with to this day. And just like you were saying, Nisha, you know, the community of lawyers that I rely upon from Berkeley Law experience still is the DPC community. And without a doubt, the clinic definitely deeply affected the trajectory of my career. You know, my first job out of law school was to go to a big law firm, Sidley Austin, but I chose that law firm largely because they had taken 20 death penalty cases out of Alabama in connection with Bryan Stevenson's Equal Justice Initiative. And immediately I was excited. I probably spent way more time than I should have at the law firm working on this pro bono case. My client, Corky Snyder, had, among other claims, an innocence claim that was particularly interesting and powerful. And that claim took me to Alabama probably 10 or 15 times to investigate those potential facts that would support an innocence claim. And I was a new lawyer, and it was extremely exciting, you know, going to rural Alabama. This was in Talladega, where the triple murder that he was accused of committing occurred. And it's a whole nother universe. I mean, it was you know, going to trailer parks in the middle of deep woods and, you know, knocking on trailer doors and having people tell me to get off their property or else they'd shoot me. And you know, getting to work on that early on was very meaningful for me. It was fascinating. We did work up his habeas petition, and ultimately the only relief that he would have potentially been entitled to was through a mitigation claim that at best would have given him life without parole as opposed to the death penalty. He was in a prison in Alabama where they didn't provide quality medical care, no surprises there. And he had debilitating back pain, and he decided that he didn't want LWOP. He didn't want to be back in general population as an old man with back pain, and instead he took his life. So it was a you know, very sad moment in that case. Quickly thereafter, I took on another case, trying to get a new trial for really a boy, an 18-year-old man in Oakland who had been convicted of murder. We tried to get him a new trial. I believe I consulted with Ty and Liz about that case. We were unsuccessful, and after about 5 or 6 years of being at the law firm, being kind of dejected about the outcome of those cases and being at kind of a moment where I thought that it would be a good time for me to get a better fit for what I wanted to do. I got a job with my current firm, Rosenbein, Galvan, and Grunfeld, which is a civil rights firm, which practices complex federal and state litigation. Much of our casework is centered around prisoners' rights. We represent, almost all mentally ill people who are incarcerated in CDCR, people with disabilities in CDCR, people on parole through CDCR. One of my first cases in 2014 that I got to work on was a class action against the Monterey County Jail. It was a conditions of confinement suit, largely centered around medical care, mental health care, safety, dental, and ADA disability issues. And within about 1.5 years, that case settled. We won a preliminary injunction. We won class certification. The county came and settled with us. We drafted up implementation plans that would get the county and its for-profit medical provider to engage in reform activities. And we appointed 5 different neutral monitors to monitor the compliance with the settlement agreement. And that case is still going on. One of the second great cases that I worked on that, again, I find is a direct line from the death penalty clinic was a case on behalf of a man named William Sassman. He was an inmate at CDCR, or incarcerated person at CDCR. And he was the father of several children, and he was denied the opportunity to participate in CDCR's alternative custody program, which was billed as a program that allowed people who are low-level, nonviolent offenders to participate towards the end of their incarceration by being on home confinement the last 2 years of their term. And even though it was billed as family reunification, bringing parents back to their children, it was only available to women. It was only available to mothers. So we sued CDCR under the equal protection theory, and we actually won. He was allowed to participate in the program towards the end of his term, and we opened the program up so that it's now available to both fathers and mothers. Other cases that we work on at the firm include First Amendment cases. I do FOIA cases on behalf of nonprofits. Liz briefly mentioned a case in which we sued the Trump administration last year when the president was trying to really gin up support for his 2020 election campaign by targeting Chinese Americans and putting a wholesale ban on the WeChat social application that's largely used by Chinese Americans. And he had 45 days basically to have one of his departments create the rules that would basically ban this social app. And we brought a preliminary injunction before the federal court and obtained that federal court's injunction just on the eve of the day that ban was to go into effect. The DOJ promptly sought a stay. We were able to convince the court not to stay the decision. The Ninth Circuit also did not stay the decision. And when the Trump administration transitioned over to the Biden administration chose not to follow through with the ban. But one of my proudest moments working at my current firm is actually being able to be the lawyer for my mentors. The clinic actually hired our firm because we do a lot of civil rights work. We often serve as experts for attorneys who are seeking fees in their own cases where they have federal fee shifting statutes. And the clinic needed a lawyer to help obtain the fees for the empirical study that Liz was talking about in connection with the Weaver case. They had spent more than 10 years trying to obtain discovery from the County of San Diego in connection with this selective prosecution theory that they wanted further examine. And after obtaining that discovery, they were entitled to fees. So they sought out our law firm, and working with Sandy Rosen, my partner, I was able to actually be the lawyer and represent my mentors, which was one of my proudest achievements as a lawyer. And we were able to get them a confidential but very nice sum for all of their work. And
That went back into the clinic.
Yeah, went back into the clinic. that funded the third lawyer for the clinic for a few years.
yeah.
For sure.
So tying it back all together, the death penalty is consequent. The death penalty clinic is consequential and directly tethered to my work, not only because Liz was a reference for me for my present job, and without her good words, I wouldn't have gotten the job, but also, just as you said, Nisha, your resilience inspires me. Constantly we're dealing with the California Department of Corrections or county jails, where our clients and our class members aren't getting the care that they need. And we constantly have sad stories. And we need to be resilient as lawyers to continue fighting this work. Just last week, we have a case against the County of San Diego, another conditions of confinement lawsuit, in which we're trying to get a lot of reforms. The San Diego County jails have one of the highest death rates in the nation right now. Already this year, 18 people have died in the jails. Last year, 18 people died in the jails, and that was triple the national rate, higher than the rate of deaths at Rikers Island, which has more people and fewer deaths than San Diego. We brought a case against the San Diego County jail system. The court denied our preliminary injunction that was all centered around reforms that would ensure that people were less likely to die at the jail, and just last week actually dismissed our case, giving us leave to amend. But it was a crushing defeat for us, and it's the resiliency of the clinic and your work that you do that inspires me to continue. So thanks for everything that you do for all of us. And yeah. Sorry, Nisha, I was going to take your seat.
Musical chairs.
Yeah, I'll take your seat.
Please.
Sorry, Nisha.
Thank you.
Do your name tag?
I'm sorry.
No.
Yeah.
Good morning, everyone. Now, I grew up in the Black church, so we do call and response. Good morning, everyone. First of all, Liz, Ty, Berkeley Law, I'm just super honored and excited to be here. It feels like I graduated literally yesterday, because I'm literally yesterday probably. But when Ty and Liz asked me to speak, it really just brought me back to a time of reflection about the death penalty clinic. So much of my experience with the death penalty clinic was one of a lot of healing and a lot of reflection. So the way I got into the death penalty clinic was actually through a conversation, and relationships matter. I think the common story that you'll hear in the next few minutes as I talk about my experience is that relationships matter and stories matter. So the first introduction that I got to the death penalty clinic was actually outside of the context of the death penalty clinic. It was with Liz. And I happened to sit on the Berkeley Law Admissions Committee. And Liz was my mentor at the time. She was the person that made sure that I just didn't admit any and everyone to Berkeley. And because I guess my fierce advocacy for a lot of the students, Liz asked me if I would consider joining the death penalty clinic. And up until that point, I wasn't considering any clinic at all. I was about to be my third year. I, had already secured my federal clerkship. I've already did the things that I needed to do. So I was like, I'm chilling. I'm chilling my third year. But apparently, Liz was very intentional about, making sure that didn't happen. So with that, I had applied to the death penalty clinic, and I did get the congratulatory email, like, congratulations, you got in. And I was like, it's kind of because I know the director. But in any event, I think it was also because a lot of my shared experiences, as I would later learn, really served as an asset to much of the work that we did on behalf of DeForest Johnson in Alabama. So one of the things that I think was really pivotal during the case of DeForest Johnson was the ability to tell stories. So at the time that I joined the death penalty clinic, DeForest Johnson, it was years since he was already convicted of murdering a sheriff deputy in Alabama who at the time was undercover, essentially at a hotel. Despite the fact that DeForest Johnson had a very strong alibi, he was literally across town that night. Despite the fact that the evidence against DeForest was so flimsy, and essentially the only evidence that was used to support his ultimate conviction was by a woman who had heard through a three-way call that a man who happened to be named DeForest, which not buying that, but okay, admitted to the murder of this officer. Despite all of that, DeForest was, essentially sentenced to death. And my task during my time in the clinic was to really bring to light stories, was to really illuminate stories. With Ty, who also served as my mentor, we went to Pensacola, Florida. I remember that. And then we later on drove to Alabama to collect stories. And frankly, it was traumatic, but not simply for the reasons that I think many of my classmates talked about, vicarious trauma. It was traumatic because it was a re-traumatization of many of the things that I went through as a child. So one of the things that I did in preparation, and just because I'm going to therapy, is I took, raise your hand if you've heard of the ACE study or the ACE test. So the ACE test is the test that, essentially measures adverse childhood experiences. And over 68% of individuals, and essentially the ACE test tests for about 10 different childhood experiences that one could have experienced before they turned 18. And the ACE test, a normal score is 1. So about 68% of individuals or Americans have a score of 1. I have a score of 8. So much of the stories that were shared while I was documenting evidence and taking in stories for the purposes of affidavits really reflected many of the stories that I grew up with. So Forrest Johnson, before he turned the age of 18, had already seen several murders. He woke up to a relative who was dead, right? He woke up to a dead relative. He experienced gang violence and just like critical rejection over and over and over again. And much of what allowed me to not only speak with the families, but to identify with the families and make them comfortable enough to talk with me was the fact that not only did I see them, I empathized with them. So a lot of the meetings that Ty and I had, much like what Van said, like we had to bring our own agenda. If we didn't bring our own agenda, Ty was not talking to us. But many of the meetings that we had was Ty really asking, obviously what was going on in the case, what was the evidence that we were using to support our argument, essentially for post-conviction consideration, because what we were essentially arguing was, and I forget the term, but essentially like just an incompetent attorney who essentially did not share much of the story of DeForest Johnson. And because much of the story of DeForest Johnson was left out, including many of the facts that I mentioned, he was sentenced to death. And that could have been prevented. And we're still fighting that to this day. So a lot of the meetings that I ended up having with Ty, and later on Liz, was I am experiencing a level of trauma that has me concerned. I remember going to Liz, I think it was mid-semester, and I was just saying, I am really depressed. So a lot of the experience in death penalty clinic really really started my ultimate journey of healing, because I knew that by the grace of God, the only thing that was sitting between me and DeForest was a mentor, was a sponsor, was somebody who said, listen, okay, you sound pretty smart, so let's take you to this after school program where we can talk about debate and the founding of the country's history, right? So what Liz and Ty have done just over and over again, even after I graduated from Berkeley Law, is they kept in touch with me just to remind me that I was that I had a attorney-client privilege, and I that went with me to the grave, and which, like, literally it still shakes me. Like, I asked them right before, I was like, can I even mention the name? Because I want to know what I can and can't say, because I got 2 bars. I'm not trying to get in trouble. So but they kept in touch with me, and they kept in touch on my journey. So after I graduated from Berkeley, I went to Ropes and Gray for a year, and I was just sharing with them that because I was a first generation everything, I didn't know what I didn't know about navigating this space. Like, the billable hour, I should have been fired. Like let me just, like, it was like, but again, I had a lot of mentors and sponsors who saw something in me that I didn't see. And they, essentially put me in a lot of cases. They put me in front of a lot of partners, and they allowed me to essentially grow in a way that was insightful and meaningful to the rest of my career. And then after that, I did a federal clerkship in the Eastern District of California. And much of the work that I did with the death penalty clinic actually helped us with a lot of the habeas cases that we were hit. As some may know, the Eastern District of California is probably one of the hardest hit districts in the country, whereas on average, a sitting judge has about 60 cases or maybe even 40 cases. On average, a sitting judge in the Eastern District of California had about 125 cases, all pending at the same time. So juxtapose that with having a judge, Judge Kimberly J. Mueller, who had a very, very high work ethic. We were oftentimes the clerks who never made it to happy hour. So that was an experience in and of itself. And then I went to Quinn Emanuel. But the thing that kept me going to ultimately found my firm is the power of stories. It was the power of stories that allowed me to connect. You can leave it. It's the power of stories that allowed me to connect with many of DeForest Johnson's cousins and aunts and uncles and friends and high school friends and family members, to essentially elicit or solicit really, really powerful stories, which, are now in the record of some of the briefs that we filed in the state court in Alabama. Is the power of stories that allowed me to ultimately start Firm for the Culture, which is a firm designed to help social entrepreneurs and diverse founders trademark their brand, monetize their brand, and scale their social impact. And it's the power of stories that allows me to talk about the intersectionality of diversity and social justice and social impact and intellectual property. Because intellectual property is the continuation of the mattering of Black and Brown lives. And essentially what I share oftentimes, I shared this when I was asked to give a talk a few weeks ago, was about how Black Lives Matter was founded. So Black Lives Matter was founded by Patrisse Cullors, Alicia Garza, and Opal Tometi in 2007 after the killing death of Trayvon Martin and the acquittal of George Zimmerman. And they had been on the national stage ever since then. They were there in 2014 with Sandra Bland. They were there in 2013 with Sandra Bland. They were there in 2014 with Eric Garner. They were even there during one of the most controversial elections in our recent history, the one between Trump and Hillary. But despite all of that, they weren't encouraged to protect their intellectual property, specifically trademarking the brand Black Lives Matter. And when they finally, got told, okay, hey, maybe this is something that you should protect, the United States Patent and Trademark Office refused to give them registration on a relatively new refusal ground called failure to function, which essentially says that because everyone is essentially using it, no one person, including the founders, could own it. So fast forward to 2020, you know, COVID happens, social dissatisfaction rises in light of George Floyd's gruesome murder being made viral all across the world. And Black Lives Matter is brought to the stage once again. But unfortunately, because they didn't have their brand federally registered and thereby did not have a lot of policing mechanisms to stop their brand from being utilized from individuals and organizations that weren't necessarily aligned with their cause. There was a rogue organization also called Black Lives Matter that did not at all align with their cause. And in fact, it was made by one person who had a P.O. box in Santa Clarita, California, who raised over $4.4 million that was misdirected, that was taken away from the organization that Patrice, Alicia, and Opal had founded. That's the story of intellectual property when we're talking about diversity. And the power to craft stories in a way that emphasizes how important it is to protect the mattering of Black lives, not only in cases of civil rights, not only in cases of labor and employment, not only in cases of domestic violence, but also in cases of generational wealth when it comes to their intellectual property and their creative contributions to the culture. Stories allow us to show the importance of that. So thank you, Liz and Ty, for really emphasizing to me that not only did my story matter, but stories like mine mattered. And because of that, you know, I think that me and my team at Firm for the Culture now have the capacity and capability to shift the world. So thank you.
Oh my goodness.
You say in the middle.
We had no, I promised you, we had no idea.
Okay.
You're in the middle now.
Oh, hey.
Yeah.
Although this is going to go down.
There
So
we
we
go.
have like 5 minutes or so for questions.
Yeah, or even more. Because Veronica says there's
Yeah, like
latitude.
it's like a little
So
delayed.
Here, sit on
Okay, sure.
In the 70s, I graduated in 77. I was a public defender in LA County in the 90s, and I was doing death penalty. And people, Pomona had a lot of death sentences. And the way I got out of having my clients sentenced to death or during the penalty phase, I discovered declaring doubt 1368 and also not guilty by insanity plea. And I would get psychiatrists to concur with me that my clients were incompetent or insane. And even though they may have come back competent and not insane, they would prolong the case and would lay a record so that the DA later on may not want to pursue the case because their client had mental health issues. And this is before the Turing cases where you can't execute somebody with a low IQ. Mm-hmm. And that's a lot of litigation on that. What is a low IQ? I might have a low IQ. But some of the cases I did in the 90s are up on appeal on habeas. Mm-hmm. I've had a couple of cases that were clients were released. They got life without parole, but they were based on the felony murder rule. Mm-hmm. And then on appeal on a habeas, they were found not to be major participants. They were the driver of the car, and they got released after doing 20 years. Mm-hmm. And I later became a judge in 2008. Arnold Schwarzenegger appointed me. He had the guts to appoint public defenders. Unfortunately, Greg Davis did not like appointing public defenders because of Rose Byrd. She had gotten defeated. And Cruz Reynoso, who was also, they're both Berkeley grads. They got defeated in the election, got kicked out. So, but I want to thank the work you do because I know that I may have a few other clients out there that are really big. And sometimes you have to argue ineffective sometimes, But I do not believe in falling on the sword. I knew I didn't affect representation. And it's because I went to Berkeley Law.
Thank you so much. Yeah.
I have a question, especially for
You can call me Ruky, like Rookie of the Year.
My name is Renee Rambo Ron Hey, hey. And one of the things that happened while I was there, we were looking at alternative things for dealing with the juveniles and keeping them not in the criminal justice system, but alternative methods. And what happened though, is the age for being eligible to be treated as an adult lowered, if I recall, from 14 to 13, depending on the crime for murder. We had disproportionate numbers of minorities, especially Blacks, that always had to go to Spofford Detention Facility as opposed to the group homes or being able to be monitored from home. Since you are practicing both in New York, or admitted both in New York and admitted here, and I didn't do anything legal. I wasn't a member of the bar. I was in charge of, I was a director of planning and management analysis, looking at what we were doing numerically with the numbers and projections. What, if anything, is happening to deal with what this age, 18, then you're gonna be the death penalty in the United States, especially in a state like New York where the Department of Juvenile Justice went back into the criminal justice system?
Yeah, so just to understand your question, are you asking, because I'm barred in New York and California, am I aware of like the state of matters in New York regarding like either the death penalty or, so I'll concede I am not aware of that. But what I will say is that it seems like it's endemic, or it's part of just a structural system of just, again, not seeing the humanity in people who found themselves on the wrong side of the track. While I was at Quinn Emanuel, I engaged a lot of pro bono litigation to essentially get jailers out of jail into warm places because they were literally freezing to death. So if nothing else, and that happened in the early, that happened less than 3 years ago, or 4 or 5 years ago. So if nothing else, what I can say is I'm not at all confident if I'm just being frank with you, that much has been done by way of just accommodating the youth who've essentially, may not have had access to a lot of resources. As you may know, in New York, it's a very hierarchical school system. I believe I ran across an article a couple of days ago that specialized high schools like LaGuardia and Brooklyn Tech and Stuyvesant, they actually took back consideration of diversity and inclusion in admitting students into the school. And that's an issue, right? Because when you're saying that we're not going to consider your upbringing and how much you've had to fight to just get to school in the consideration of whether you would be a stellar candidate for this specialized high school, which, kind of like how certain judges funnel to the Supreme Court, these schools funnel to Harvard and Stanford and NYU and Columbia. That can cause or perpetuate or amplify the structural and institutional issue. One thing I will say on a related matter, and the reason why, and again, maybe this is presumptuous, but one thing I can say is I have a brother who has autism and Down syndrome, and he's a big man. He's big. I like to call him my little big brother. And one of the things, because he's nonverbal, when he gets agitated, he, waves around, acts out. My mom is still in the projects, my mom is still in Brooklyn, and my mom is a single mother. And during many of his instances where he acted out, they handcuffed him. And they threatened to arrest him, nonverbal. So if that's any indication of how New York handles children, I'm not at all confident that they're doing much more than what you've seen them do during your tenure as a director.
And I kind of gave you, unfortunately, I was there in 1990, so just to put it in retrospect, and that's when they started to lower the age where the youth could be considered, and they moved Department of Juvenile Justice back into the criminal system. But thank you very much.
Of course.
I'll just add one quick thing. This is not I don't want to call this a note of optimism. I'll just say it's an important development that since the 1990s, there's been a tremendous amount of research on brain development everyone up here knows it and is well versed in it, showing that brains develop much more slowly than we thought, and that most people are not developed in terms of neurologically as adults until they reach their mid-20s or even later. And that is starting to have an impact in states like California and across the country in terms of rethinking the punitiveness of sentencing. So making individuals who were, in California specifically, just to give an example, who were 23 and younger eligible for resentencing in some cases. So there's beginning to be a shift. I wouldn't say that there has been a systemic move, as there should be, to re-raising the age at which someone can be treated as an adult, but maybe that research bodes well.
The law that the clinic helped get passed recently regarding preemptory strikes in California, do you see that as scalable to other states?
Yeah, and in fact, I didn't mention it, but on one of the slides, if you go to the death penalty clinic's website, where did I put it? No, I didn't. Oh, there it is. It's on the very last. Yeah. So on that slide, on your left, there's a page, or on your right, sorry, there's a page that says state by state reform, where what we're doing is trying to track what's going on in other states. Things in Colorado, where you are, Anna, have not been going well yet. But there are a number of states. I should mention that we followed the state of Washington. So we were not the first innovators in terms of this reform. We very much tracked what happened in Washington. But now states like Connecticut, Massachusetts, New Jersey, just to name a few, are beginning to implement the kind of reform. Michigan just introduced a statute. Arizona's solution to the problem was to abolish peremptory challenges, which deserves a longer conversation. But we're trying to keep track of what's going on across the country. Sometimes it's very visible, and sometimes it's going on below the radar in terms of a commission that'll be appointed, or that's doing work that you can't necessarily find easily. I would like very much for this to be scalable. I would like very much for this to be part of a nationally funded project that looks at the states, because I actually believe, whether it's by judicial rule revision or by statute, that a lot of states with the proper kind of guidance and expert assistance would be very open to looking, re-examining this question. It's not something the clinic has the financial capacity to launch. I've knocked on a few doors, I'll just say, unsuccessfully. But you can imagine a number of organizations, national organizations, that might be interested. This is very much a racial justice issue, but it's also an issue, frankly, about wrongful convictions. When you're talking about juries that are racially discriminatory, juries from which a lot of people are excluded, et cetera. So that's a long answer to a short question. I think are we good? Yeah.